Welcome everyone. Yes, hi everyone. My name is Wayne Tanaka. For folks who don't know me, I'm the director of Sierra Club of Hawaii. And welcome to our webinar regarding the Pōhakuloa military lease. And specifically what may be happening next in the Army's uh, proposal to retain the lands it's been occupying for the last 65 years. First, I just want to say thank you so much to everyone who came out, who testified, who organized, who spread the word about the really incomplete FEIS, or Final Environmental Impact Statement that the Army submitted in furtherance of its proposal. Because of all of you, the BLNR, the Board of Land Natural Resources, made the obvious, but in common sense, but also really historic decision to reject the environmental impact statement. And so, because of your efforts, I think we really made a strong statement that, the people of Hawaii, we care about we care about our constitution, our public trust, and our state environmental laws that protect the cultural and environmental integrity of our home. But as many folks know, that rejection was really just the first step, the first skirmish in this fight or this discussion about Pōhakuloa, and really more generally whether and how Aina should be used or is used for military training. And so almost immediately after that decision, people started asking, so what happens next? Like what's the next things that we have to look out for? And fortunately, we have been able to collaborate with Kalahui Hawaii, Native Hawaiian Legal Corporation, and the Office of Hawaiian Affairs to bring together some of the foremost legal experts in our islands in environmental and Native Hawaiian law to help us all think about that question about what's happening next. And so before I introduce our panelists and moderators, I do want to say thank you so much to our interpreters, Laura and Michelle, who are providing ASL sign language interpretation. And also too, while we have some set questions that will help us kind of think about the legal processes and opportunities for public input and comment and intervention, we do want to have hopefully some time to answer audience questions. So if you do have questions as the discussion goes on, you can put them in the Q&A. So there's like a little button on the bottom middle right portion on your Zoom screen, if it looks the same as mine, and you can enter your questions there, and you can try and answer as many as we can at the towards the end. And so without further ado, I'll go ahead and introduce our panelists and our moderator. First, we have Lena Alalay. She is a chief advocate at the Office of Hawaiian Affairs. She came to the OHA from Earth Justice, where she served as a senior associate attorney for 6 years, working on Native Hawaiian water rights, endangered species protection, clean energy, and other INA-related issues. She actually started her litigation career at the Native Hawaiian Legal Corporation and also worked in private practice for Lung, Rose, Voss, and Wagenald on construction and complex commercial disputes. And at the Office of Hawaiian Affairs, Lena Ala leads the advocacy and compliance divisions, which includes, OHA's co-trustee duties for Papa Hanao Moku'akea. Our next panelist is Ashley Aubrey. She's from Kona, Hawaii Island, and she is a senior staff attorney at the Native Hawaiian Legal Corporation. Her work focuses on protecting Native Hawaiian land and water rights, defending sacred and cultural sites, and ensuring that the state upholds its trust obligations to Kanaka Maoli and for our public trust resources. And finally, as our panelist, David Kimo Franco, also an attorney, and he actually worked with both Ashley and Lei at the Native Hawaiian Legal Corporation. He was also the attorney for Uncle Ku Ching and Auntie Max Kahaoleleo in the Ching v. case, where the Supreme Court reaffirmed that the state had failed in its public trust obligations to monitor and protect the public trust and ceded lands occupied by the U.S. Army at the Pōhakuloa training area. And finally, our moderator today is Heilani Sonolopale. She is a Kanaka Maoli community leader, organizer, working at the intersection of Hawaiian sovereignty, self-determination, and climate justice. She was born and raised on Oahu, and she traces her ancestral roots to Hawaii Island, Kauai, and Oahu. And again, just so grateful to have such powerful people, knowledgeable people here today. And without further ado, I will hand this off to Heilani. So Heilani, the floor is yours. Thank you.
Mahalo, Wayne. Thank you for that that introduction. And before we get into the questions, everyone, I just kind of wanted to give the context to how we got here. I don't want to take up more than 3 minutes. It's just going to be a fast review of the ceded lands, quote unquote, the ceded lands or the Hawaiian Kingdom Crown and Government lands. So we want to talk about these lands that is currently being leased by the U.S. Army. Where did these lands come from? Who owns these lands? These lands are Hawaiian lands. So in traditional times, we've been here for over 2,000 years as the indigenous people of this land. We saw land not as a commodity, but as part of our ohana. There was no concept of private ownership in traditional times. And we actually belonged to the land. The land did not belong to us. Hawaiian Kingdom was united under King Kamehameha I in 1810. 1848, we have the Mahele. Under the rule of King Kamehameha III, he divided these lands into the Crown, Government, Konohiki, and Maka'ainana lands. Most of over two-thirds of the lands were put aside in the Crown and Government lands, and we're talking about over 2 million acres of lands. These became the Hawaiian Kingdom national lands. And despite the fact that they were called the Crown and Government lands, written into the titles always um, that the title was subject to the rights of the native tenants. And so the Maka'ainana, the native people of the land, always had um, always had access. It was supposed to be protected um, under uh, under this mahele. And so what the mahele did was it took the communal ownership of the land and privatized it, quote unquote. And that began the long history of land loss in Hawaii. 1893, the overthrow happened, and the overthrow of the Hawaiian monarchy. It was backed by the U.S. government. On January 16th, 1893, the U.S. Marines landed in Hawaii, invaded Hawaii, and the U.S. military never left. A small group of businessmen, white businessmen, overthrew the Hawaiian kingdom, overthrew the Hawaiian monarchy, and imprisoned our queen and seized, quote unquote, seized control of these 2 million acres of lands without the consent of the Hawaiian people and without lawful authority. And even the U.S. Public Law 103-150 cites this. The U.S. has actually admitted to this crime and the wrong that they did to Hawaiians by seizing these lands, which was the lifeblood of our people. Without the lands, we were part of the lands. We had this connection to the land spiritually, and it fed us, and we took care of the Aina. So we had this reciprocal relationship with the land. In 1894 to 1898, the Republic of Hawaii illegally claimed these lands. And I want to quote Professor Williamson Chang, who is a professor at the UH Law School. And he states the Republic of Hawaii could not transfer what they did not own. Neither the provisional government nor the Republic had the authority or the right to alienate them. Because in 1898, the provisional government or the Republic of Hawaii transferred these lands over to the U.S. after the U.S. Congress passed the Newlands Resolution, which, quote unquote, supposedly annexed or illegally annexed Hawaii into the U.S. And this was a violation of their own laws. So we know that we weren't technically annexed into the U.S. There is no treaty of annexation. They're supposed to annex Hawaii through a treaty, and that was never done because they could not get the three-fourths vote. Hawaiians were also protesting, and yeah, it was a joint resolution. Um, Hawaiians were also protesting, and that's how we got the Kue petitions. And they actually stopped this illegal annexation from happening. But it finally did go through, even though it's not legally binding. Uh, and these lands for which the U.S., the Republic of Hawaii never had authority over in the first place was transferred to the U.S. And this is where these the title of these lands is contested as well. In 1959, the statehood vote happened. Hawaii was put when so Hawaii was a territory, quote unquote, from 1898 to 1959. We were on a list of colonies or territories to be decolonized and the UN. The US wanted to get us off that list. They held a plebiscite or vote, and they only had one question on the vote. Shall Hawaii immediately be admitted into the Union as a state? This was an illegal vote. They did not give all the options. That they didn't give independence as an option. They didn't give us the choice to reclaim our kingdom, our lands, and so we became the 50th state because 132,773 people voted yes. There was no option for independence or the restoration of the Hawaiian kingdom. These 2 million acres of lands, was then transferred over to the state of Hawaii, quote unquote. And as a condition of the Admissions Act, these lands were to be held in a public trust. One of the conditions of the public trust was for the betterment of the Native Hawaiians, small and Native Hawaiians, as defined under the Hawaiian Homes Commission Act. And it was also supposed to be used for public use and education. 1960s, the U.S. military um, signs the lease. So in 1964, I believe it was, the U.S. military signs the lease with the state of Hawaii, and the U.S. Army gets control of 22,000 acres, 22,971 acres of lands just for $1 for 65 years. And many of these areas that the military got control of were zone conservation, and were also quote unquote Hawaiian homelands. Okay. Then we're now to the present. These lands rightfully belong to Hawaiians. They are Kanaka Maoli lands. We never gave up ownership to these lands. They were seized illegally without our consent, and it's part of the illegal overthrow of the Hawaiian kingdom. And I just wanted to put it in context. So Auntie Maxine Kahaulilio and Uncle Kuching challenged the state in saying that they violated its trust duty to malama these lands, and they won. The state was ordered to malama, quote unquote, aina, or to care for the land. And we are continuing on this struggle. And I want to end my context, putting all of this in context with a quote from Hononeke Trask. And she says, the state makes millions of dollars from these lands, all the while pretending to be the neutral trustee of a stolen estate. These lands are our lands, and everyone benefits and has benefited off of these lands for many, many years. These Pōhakuloa lands that we are now in discussion about are Hawaiian lands. They're stolen, and we never gave them up. So I just kind of wanted to put that in context before we get to the first question, because most of the questions that we will be posing will be around the EIS and around this whole process that now the Board of Land and Natural Resources, which holds most of the public trust or these quote unquote ceded lands, it holds most of these lands in under their department, even though now it's being transferred out. Okay, so on May 9th, I'm going to get to the first question, and thank you for allowing me to put that all in context because it's important, and this is why Hawaiians show up. On May 9th, the BLNR rejected the FEIS, which is supposed to document the environmental impacts of the Army's proposal to retain the lands it is currently leasing in the Pōhakuloa training area beyond the 2029 lease expiration. So Ashley, can you talk about what happened, the basis of the DLNR decision, and what BLNR recommended the Army do should it choose to revise the FEIS, which is the final EIS? Can the U.S. Army appeal the BLNR's decision if it wants to continue to retain the lands of Pōhakuloa? If so, are there opportunities for the public to comment or for the people to intervene? Mahalo.
Mahalo, Heleni. I appreciate that context. I mean, grounding us in why everybody is here is important. And as I think Wayne said in the beginning, right, like we're here now, or, because we've been in this process of this environmental review, and this is like the first challenge of many probably to come. So important to understand the background. But yeah, so what's been going on is, and I'm kind of going to back up just for the sake of making sure everybody's on the same page. But the environmental impact statement issue, this is all grounded in the Hawaii Environmental Policy Act. You'll hear it called HEPA. You'll hear it called HRS Chapter 343. And basically that's triggered because this is a use of state land, obviously, as we were just talking about. So on May 9th, the BLNR reviewed the Army's final environmental impact statement for the Pōhakuloa land retention. And as we talked about at the last webinar, really what the law requires is that the contents of an EIS fully declare all environmental consequences of an action, and it's supposed to discuss all reasonably foreseeable consequences of the proposed action. And as we talked about, and as I think, everybody wrapped their heads around it, and that was what was so compelling about the testimony, was there was a number of significant deficiencies in that EIS. And I think in reading like the recap, there were over 1,500 written testimony, 140 plus, people coming in person or on Zoom to talk to the BLNR about these issues. And so the BLNR ultimately decided not to accept the EIS. And for those who weren't watching, and the initial motion was to accept, but the majority didn't agree. So then the motion flipped, and now it was a vote not to accept. And that's what the majority agreed with. But in doing so, there were statements made by several different BLNR members about the insufficiencies. And as part of that motion to reject this environmental impact statement, they did include guidance that, I guess, based on the testimonies and based on their review of the document, the things that were lacking, and that what the Army should consider if it does decide to come back and redo this EIS. And for the sake of just like making sure everybody knows what was said, they talked about the analysis of impacts to traditional and customary practices and the application of a kapa'akai analysis to this type of document. They talked about the Army pulling in some kind of codified record of their consultation because there was an issue about whether or not Ahamoku was properly consulted with. They mentioned the need for a complete biological opinion, an accurate weapon and UXO inventory that would be acceptable to the staff and to the board, a complete greenhouse gas emission data inventory, cumulative analysis of impacts, and that would be on federal and state land, a detailed inventory of the disposition of ibi kupuna and moipu, a clarification of whether the National Historic Preservation Act, Section 106 applies, because the Army did try to label this an administrative action, like as if it was just a mere transaction and no big deal. It doesn't rise to the level of Section 106. A justification of why the area of potential effects was narrowed, a more serious consideration of the no action alternative, which I think many of us on this webinar would be interested in as well. And then the issue about the fact that this is conservation land and this type of use is completely incompatible with that land designation. So all of that is what happened. But ultimately, yes, to answer the question, yes, the Army could appeal. The administrative rules as part of of HEPA allows for an appeal to the Environmental Council, and they've got 60 days from May 9th to do so. And the way I understand it through the rules is they run it sort of like a contested case hearing, but it is an appeal. So you've got the applicant or the Army as the appellant, and you've got the BLNR as the agency decision maker appellee. And so it would just run through the course of that hearing, and there would be findings and there would be a decision. And I guess that's the crux of the appeal. That answers the question.
Thank you, Ashley. Can you explain to people what the Pa'akai analysis is, just for people who don't know what that is and what HEPA is?
Sure, yeah. So Kapa'akai analysis is basically the state has a constitutional duty to protect and preserve Native Hawaiian traditional and customary practices. And there was a Supreme Court case back in 2000 that basically created an analysis or put forth an what they call an analytical framework that these agencies are supposed to go through when they think about when they're making a decision and how that impacts traditional and customary practices. So that would be identifying the various practices and resources that are connected to those practices that could be affected by an action, the potential impacts to those practices and to those resources as a result of the action, and then I guess, mitigation or the types of action they could take to minimize the impacts to those practices and to those resources. So there's supposed to be written findings, and there's supposed to be a full, a really full analysis to show that they are meeting their duties under the Constitution. And then HEPA is environmental review law, and it's really it's a disclosure type of law. It doesn't really necessarily dictate a particular result, but the idea is the agencies are supposed to consider the environmental effects of a proposed action as part of, when they're making a decision. And so those two, I mean, they kind of go hand in hand, especially when we're talking about natural and cultural resources that, Native Hawaiians rely on or view as sacred or important to their identity. And so, yeah, that's.
Thank you, Ashley. I'm going to get to the next question. What if the BLNR approves the new FEIS? And I think you kind of answered this already. What comes next, legally speaking, in terms of the U.S. law? What opportunities will there be for public comment or legal intervention in these legal processes? So I think you kind of, oh, I'm sorry, I skipped the question. Sorry, that was Kimo's question. Sorry, number 2 question. If the Army instead chooses to redo its faulty EIS, what will that process entail? Will there be opportunities for public to comment on any revised FEIS either before or when it's presented to the BLNR? If so, are there any important things to keep in mind for that part of the process? And I think you kind of answered that. But in your opinion, have you heard anything about, or in your networks, have you heard anything about whether or not the U.S. Army will appeal the Board of Land and Natural Resources opinion?
I have
Decision?
not. I mean, I do recall the Army telling, the news that they understood that that was an option that they had, but I'm not sure yet whether that's something they're going to do. In terms of next steps, if they do come back with a new EIS, basically the law allows them to come back with a new draft EIS. And it's supposed to address the inadequacies of the EIS that was not accepted. And so in theory, the guidance that the BLNR did provide would be helpful. And so in terms of opportunities for the public to comment, I mean, this goes through the same process that we've seen the EIS go through initially with the previous drafts, essentially, right? So they're going to get the same requirements of public notification and public comment. So there's opportunity to review the draft and provide written comments that then would get incorporated into the final and that kind of a thing. And then the final EIS would again go back before the board, just like it did on May 9th. And so there'd be opportunity again at that point to testify. And I don't want to creep into Kimo's question, but
Yes.
with respect to the commenting on the draft, I think it's important to really offer substantive comments on the document itself. And it's really easy to want to say we don't want the military here or whatever, whatever our strong emotional feelings are about the presence on this INA. But I think, with the way that the law functions, if you are going to have the opportunity to appeal acceptance of an FEIS, you're limited to the issues that you identified in your written comments. So just something to keep in mind at that point in the BIS process, if you're commenting on the draft, substantive comments about the document are super critical. But I won't say anything else because I think he probably has more for the
Yeah. Thank you, Ashley.
Yeah.
Yeah, and you're exactly right. I mean, it's a strategy, right? It's not to say that that's all we care about is all these little things in the EIS. It's a strategy, part of a larger strategy for Hawaiian liberation and sovereignty and self-determination. Kimo, can you answer the next question. So if the BLNR approves the new FEIS, what comes next, legally speaking? And I know Ashley did talk a little bit about that. What opportunities will there be for public comment and or legal intervention in these legal processes? And anything else you want to add on that?
Okay, I want to go back half a step. So this is a little nerdy, but there's federal law and there's state law. Okay, so the board has rejected the EIS under state law. The Army has said it's going to issue what they call a record of decision, which would be basically their approval of the federal EIS. That's what they said. We don't know if they're going to do that. So somebody may sue over the adequacy of the federal EIS. In the meantime, these guys are going to, I'd say it's unlikely they're going to appeal the board's decision, and they're going to have to do a new draft EIS, which probably won't be done, I would say, till the end of the year or so. These are guesses, but I think they're kind of relatively good guesses. So let's say they go through the process. Ashley outlined. They do a new draft EIS. People comment. They change it again. They submit a final. There'll be another board hearing, right? And the board's gonna, let's say, accept the final, and everyone can testify at that point. The next part is where it gets really tricky, because there's, I guess, three major options that they can choose. One is to pursue getting a lease from the state. I think the writing is in the wall. The writing is wherever the writing is supposed to be, in the water. The writing's on the wall. There's not going to be a lease. I think the department and the board has made it clear that the lease is not compatible in the conservation district. So they may pursue a lease, but I think that's not likely. I think a more likely scenario, the most likely scenario, is that there's going to be an attempt to do some sort of land exchange where the federal government returns acreage of however amount, wherever it is, in exchange for fee simple ownership of some of that 22,000 acres of Pōhakuloa. I think that's the most likely scenario, and I think people are going to have concerns about that, but that's what people need to know. That's what the governor is talking to the military about. That's what the congressional delegation is talking about. The third option I also think is not likely to happen, and that is where the federal government simply takes the land and condemns it. And I think it's unlikely because it would poison the relationship between the federal government and people here irreparably, in a way that the water was poisoned at Red Hill. I just think it is a bridge too far, but you never know with the Trump administration what could happen. But in any case, I don't know if I should talk about this now or later, but if there's some sort of land exchange, the Board of Land and Natural Resources would have to approve it. In addition, the better reading of the law is the legislature would have to approve it too. So the folks who you elect to the state Senate and state House will have, whether they're in, Makakilo or Waimea or wherever they are in the state, they're all going to have a vote on whether to approve a land exchange or not. We'll talk a little bit more about that in a bit in terms of those opportunities, but that's sort of a broad brush picture.
Thank you, Kimo. And I agree with you. I think that condemnation is highly unlikely because it will poison that relationship. What we learned from the Red Hill struggle is that to a certain extent, the U.S. military does need public support. They have tried over and over, and Kimo, I mean, you were on the Red Hill CRI. Their public image is so important to them because to a certain extent, they do need us to they need people to be okay with them being here. And for many, many decades, it's been ingrained in us that we wouldn't have jobs or we wouldn't have, a good way of life if they weren't here. And which is all, of course, false. Um, and so I want to just go to the next question. Um, Number four, the historic preservation, and we're going to Lena Ala now. But and so I also want to ask, in addition to this question, I also want to bring up the fact that a couple days ago, the board did have a discussion on Pōhakuloa, and Chair Kai Kahele was talking about land exchanges. So you can go back and go watch it. It's on YouTube. But that was something that was floated around on the board table. So I'm going to Lena Ala, who works for OHA. I don't know if she wants to talk about this but here's the question for Lena Ala. Historic preservation came up in the BLNR's decision, namely 6E and Section 106 consultation. Do we want to raise this? And what does that mean? So that's for Lena Ala.
Mahalo, Heilani. So yeah, and Ashley also outlined one of the issues that the board members were concerned with and that they flagged when they rejected the EIS was the lack of inventory and full disclosure about cultural resources that have been found on the property in the past, as well as how the Army should be conducting Section 106 or HRS Chapter 6E during the lease renewal process. And OHA has asked from the beginning here and in other contexts that the Army do its HRS Chapter 6E at the same time as it does its environmental review. Technically under the law, and they're saying they want to delay until there's actually a conclusion of the lease negotiation. It's the same tactic they took with cleanup. Like, we don't have to talk about this now. CERCLA will govern once the lease terminates. But that's not really good faith, honestly, and that's what the Army has been asserting, that they want to operate in good faith. And really good faith would be to do HRS Chapter 6E now and include more information as part of this, public disclosure and comment process, which is what the EIS HEPA process is. They admitted in trying to defend themselves when they were given the floor at the BLNR hearing, they talked about the pedestrian surveys that they've done so far, which they themselves said are like 50 meters apart. And a pedestrian survey is not a particularly intensive form of archaeological inventorying. It's kind of like you're walking around and seeing what you find. And as we know, the areas that have had cultural artifacts and iwi kupuna are often lava tubes in this area. And that's a more intensive form of investigating the land. And we think, given what they're asking for, a renewal of a 65-year lease, which of course we oppose, but they need to be looking more completely and thoroughly at what are the resources that are affected, and really by their own admission, they haven't done the most complete survey. It's hard work. We acknowledge it's hard work. Surveying lava is hard work, but it's also important work that they need to do. And so, we're pleased that the BLNR took that position, that SHPD is now also calling for Chapter 6E compliance at the same time. Really, they're also governed by Section 106, and we would argue that this is a federal undertaking, renewal of the lease, whether they want to call it administrative. It would be a federal undertaking that would also require Section 106 consultation, which is really similar in practice to HRS Chapter 6E. But an important part of both, again, being consultation with actual community members as part of their good faith investigation of cultural resources in the area.
Thank you. As an EV protector myself, I know what 6E is, Section 6E. Can you kind of explain a little bit more about Section 6E?
Sorry, yeah, to use that term of reference. I mean, Chapter 60 is in historic preservation law generally, but it also governs protection or and treatment of ibi kupuna and Native Hawaiian burials. And so it's kind of I mean, it's very similar to what Ashley was talking about with Kapa'akai. It's identifying resources, it's determining the effects that the action is going to have on the resource, and then looking at potential mitigation measures. And that's obviously one of the most important steps is a mitigation and how we're going to protect this and what's going to happen. And under both the Historic Preservation Act, the National Federal Section 106, and also Chapter 60, there is a lot of involvement. If there are cultural sites, burials identified during the review process, then there's lineal and cultural descendants that need to be notified and have an opportunity to weigh in directly on what type of mitigation and treatment is appropriate.
Mahalo. Thank you so much.
And I don't know if David Kimo wants to add anything. I know he has a lot of experience with Chapter 60, but that's my brief summary.
Thank you. Mahalo nui. Kimo, did you want to add anything to that?
No, Lei does everything brilliantly.
Okay. Okay, so we're gonna go to the next question. I think the next question was about eminent domain or condemnation, which has been something that has been talked about in the news. Naka Nathaniel did an article. It was featured on the front page of the Kawaiʻola about this. In my personal opinion and in the opinion of my committee, we saw it as a fear mongering of, unnecessarily. And I think what May 7th showed us was that if we come together, united in our voices, that we can make an impact. And that was a very powerful moment, I think, for our community and for Kanaka Maoli. And I want to mahalo Sierra Club and all the different organizations, Native Hawaiian Legal Corps, for helping to organize that moment. And I think that has recharged us and kind of is giving us more resolve to continue seeing this forward as the leases and as this whole process comes up. Okay, so we are going to go to the next. Oh, so another question for Lena Ala would be OHA's concerns in terms of the public land trust and what is OHA's role in this whole process? Like, do you guys have a seat at the table? What's going on with OHA and this process?
So we do not have a seat at the table. We have requested a seat at the table as really a trustee of the Public Land Trust. OHA receives, everyone knows, but I'll state it again. We receive our funding as proceeds of the Public Land Trust, but we've also been really entrusted with protecting the corpus of the public lands until such times as Native Hawaiian governance claims have been addressed and resolved. So, we do see preservation of the public land trust corpus, and public land trust, again, being, as Healani has already set it out, primarily former crown and government lands. That is what the public land trust primarily is. And that's why, as Healani was explaining, these are Native Hawaiian lands. So OHA does want to assert a role at the table to really look at prioritizing Native Hawaiian claims. But we don't have a seat at the table yet. And also, kind of speaking to what others have mentioned, there is a line to walk to a certain extent with, a land exchange. What is the federal government going to demand and what can we demand back? And that is a discussion that is taking place among the trustees. As Heilani mentioned, we do have publicly noticed meetings. So this issue will continue to be raised and discussed among the trustees as we go through the process and do see what the Army actually intends to do. One of the critiques we raise is really their lack of transparency about whether they're going to go for a lease or go for fee retention, and what kind of discussion there needs to be about if they're going to go fee retention, what is due really as compensation. And it's a difficult discussion, right? Because there really is nothing that compensates for INA. But if we are to go that route, what kind of benefits or what kind of land exchange or what possibly can be put on the table that might be acceptable to OHA's beneficiaries. So that's an ongoing discussion.
Thank you. Thank you for that. And so this is a great, an interesting discussion because we're getting different perspectives and we're actually getting legal perspective. So I think that's something to take with you and whether you want to use it or not or process it however you want, that's up to you. And so the next question is regarding the final EIS for the retention, quote unquote, of certain lands that the U.S. Army leases on Oahu, including lands at Kahuku, Makua, Kawailoa, Poamoho. And I want to just mahalo everyone. Hundreds of people came out, many of whom stand with Aloha Aina every week. We're out there on the road, on the streets, organizing and standing for our Aina and protecting our iwi. I want to mahalo the hundreds who came out at last summer's hearings regarding the EIS, the draft EIS hearings. There were 3 last summer in July of 2024, and the testimony, the stories, and the mo'olelo that came out of there was amazing. I learned so much, and I think it was one of those moments in time for Hawaiians. So, so last summer they came out with the draft EIS, and the U.S. Army went around to different communities, to the 3 communities that it'll primarily affect if they retain the Kahuku, Makua, and Kawailoa Poamoho lands. And so what is your initial, this is for chemo, okay, for the final EIS. Do you have any initial thoughts or reactions regarding their final EIS and what it says? And what should the public know right now or be thinking about in your legal opinion? Thank you.
So there have been a couple of news stories, and I think that they summarized it relatively well. Just so people know, the EIS deals with 3 areas in Oahu, and there are problems in the EIS, but the bottom line is they say the Army is not going to ask to keep using any of the state land at Makua. I want people to understand there's state land sort of on the Makai side, and then the Moramauka is a huge section of federal land. They would still retain all that, but they're not going to ask to lease or use the state land, which is in the Makai part. So that's that. At Kahuku, however, there is a section of land near the highway. I'll call it the north section of the parcel, which they want to retain. And there's another parcel which they would stop using. And then at Poamoho, they would give it up entirely. So on Oahu, they would be significantly reducing the amount of state land that's used. But keep in mind, there's still the federal lands that they would continue to occupy. So I don't know, given the position the Army's taken, it's important for people to show up, but it's not critical that people, I think, it's not critical that people look through the EIS with a fine tooth comb because it looks like the Army is going to give up a lot of the land. The people who have a particular interest in Kahuku, there's a motocross thing up there. So those folks who have an interest in that should definitely look at the EIS more carefully. But that's sort of just a sort of a bird's eye view of the Oahu EIS.
Thank you very much. Um, yes, okay, so um we're gonna probably end about here. Thanks for that. And I'm hoping Kahuku comes out for the hearing on the final EIS for Oahu, um, because they do want to retain much of the land they want to retain, according to the EIS, is in Kahuku. And so that will be very important to hear from that community. So we're going to get to the question and answers now. Going through the questions on the question and answer chat. The first one is from John Olson. Greetings from Maine at midnight from a 36-year-old resident of Oahu. Glad that Pōhakuloa is at last really on the agenda. Are the defenders of Mauna Kea deeply engaged here too? And hi to Ku Ching. Um, we have Auntie Pua Case in the audience in attendance, and that would be actually a really good question for her. I'm not sure if I mean, I'm not sure if you guys can speak to one another, but that would be actually a really good one to get feedback from her. But Auntie Pua Case, Uncle Kalani Flores, Auntie Maxine Kahauliliu, Auntie Momi Green has been actively involved in testifying, not just at the Board of Land and Natural Resources, but also at the Ledge's past session where this issue was brought up. Okay, next question would be from Ronnie Igaki. Iwi Kupuna were moved. Did the Army notify the lineal descendants before this was done? And anybody can answer that?
So OHA receives notice when Iwi Kupuna are discovered. And I'm not sure which incident this person Ronnie's referring to, but there was 2021, I think it was, or 2022, and we received notice and also lineal descendants, and OHA defers when lineal descendants are noticed. So we didn't engage in the NAG process because the lineal descendants that have already been recognized for that area were involved.
Thank you very much, Linala. And that's something that is still it's not very clear what exactly happened regarding the discovery of the Moe Pu, which were important, which is probably one of the most important finds culturally. That was back, I think, in 2022. And we're still trying to gather information on that and what exactly happened. But we do know that it's some of them are being held in a trailer and that some of the lineal descendants were notified. Thank you. Amy, her question is, Aloha, could you review the current status of other leases, lands such as Kahuku, Makua, etc.?
Let me take a step back here. So when the Admissions Act was passed, there was provision that within 5 years, certain lands would be returned to the state or kept by the feds. And so basically what happened was a bunch of land in different areas all got signed leases in August of 1964. So they're all expiring. I mean, when I say all, I don't know, there may be other circumstances why there's other leases that were entered in after 1964, but the big ones are all expiring in 2029, which is why, so the Oahu EIS just came out, and that deals with Kahuku Makua, and as Pōhakuloa as well. There are no doubt other leases. What gets complicated for a lot of people, including I can't keep track of what lands are, as far as the federal government is concerned, are federal, and which ones the state has ownership of and has leases to the feds. But the big ones are all expiring in 2029, August 2029.
Thank you. I know that there are also always there's also easements as well that that are not they're smaller parcels. Thank you. And PMRF is coming up next. I don't know. I think we have time for one more question. And this is from Avalon Paradea. And she asked regarding the substantive comments that folks have written and compiled in their testimonies, can these comments be used in legal court cases? Should lawsuits be undertaken by community members and local organizations? Very good question. Thank you.
Go ahead, Ashley.
You can go.
So, the state law and federal laws are a little bit different, but for state law, in order to sue over the adequacy of an EIS, you have to have commented on it, and your suit has to be based on that comment, basically. So those comments can be very important. There are a number of attorneys looking into whether to sue over the adequacy of the EIS, both under state law and federal law. I think I saw Bianca was on the thing. Obviously, Ashley's here. I don't know if OHA is going to do anything. The Center for Biological Diversity is Max Phillips, who is interested in pursuing litigation potentially. Earth Justice has been looking at the issue carefully. So yeah, those comments can be very important.
Thank you. That's actually a really good question. So if there's something that speaks to you that you want to really take up, I suggest you put it in the next round of comments that they're going to be asking for. Okay, so I think we are down to pretty much the end, and I want to mahalo about everyone. Okay, wait, sorry, I'm getting a message. Can we
Let
ask
me,
about eminent domain?
eminent domain and condemnation are the same thing. And we talked a bit about
Okay,
that.
we did. Okay, good,
But
good.
I do want to address, because we're going to talk about this, and Ron Fujiyoshi raised it, and others have talked about it. So we don't know exactly the Army strategy going forward. But here are the things for those of you who want to work within the system, for lack of a better word. The governor is going to be appointing new members to the Board of Land and Natural Resources. Okay. Those new members have to be confirmed by the Senate. You want to make sure people who understand your perspective are on the board. So, get people to apply to be on the Board of Land and Natural Resources. B, monitor when the governor appoints new members and testify if you think they're qualified or not, or will do a good job on the board. The other thing is talk to people running for office. Like I mentioned earlier, the legislature will have to approve any exchange of lands. And so it's not too late to start talking. It's not too early, I should say, to start talking to politicians, people who are interested in running for office, to see where they stand on the military leases, and adding, providing your perspective. I think it can go a long way.
Thank you very much for that. And I
Can
want
I
to,
just add on, sorry, really quick, because
sure,
we're talking about
that's actually a really good point about
engagement
yeah.
with state processes, and OHA is a quasi-state agency. And I just wanted to be clear because I saw some of the comments. OHA's position is evolving. The trustees are elected, and again, all our meetings are publicly noticed. So if you do have mana'o you want to share, bring before the board, you're welcome to reach out to your trustee, welcome to tune into meetings, and participate in that way as well.
Yeah, and I think it's important. Thank you for bringing that up, Lena Allah, because it's not clear what direction the Office of Hawaiian Affairs is going to go. And it may be in the best interest of the community to kind of help to sway that where the board will be going in terms of their decision making. And so I kind of wanted to end with everyone saying a few words, just kind of closing statement about moving forward and kind of like their thoughts on what we should be focusing on next. So maybe we can start with Ashley.
Yeah, sure. I mean, I don't know that I have a whole lot to add to what was already said other than, I really enjoyed being a part of the process and seeing everybody come out and seeing the interest and the kind of movement forward of our Lahui on this issue as we've seen in the recent past with Mauna Kea and everything. And I just hope to continue seeing that. And I think to the extent that people ever have questions, I hope that, we can be resources outside of this as well. And yeah, just really staying vigilant and paying attention to what's going on and making your voice heard. I think that's a super important thing because there's going to be a lot of mini battles to get, to win the war, I guess, for lack of a better way to put it. And to the extent that you can make your voice heard, I think that's important. So mahalo for that.
Thank you. Thank you, Ashley. Kimo and Kimo, you have any other thing to add? I mean, I think focusing on the next appointees to the Board of Land and Natural Resources to prepare for the next hearing is going to be important. But
Yeah,
anything else?
I just say that, well, I'm here to provide information to you folks. I don't think any of us are here to organize. Well, I think that's not the purpose of this Zoom. Somebody needs to take leadership in terms of coming up with strategy, whatever. If you have legal questions, that's why we're here, so to give you the context for decision making, but hope that somebody will take the lead in organizing the community in terms of what the vision is, what the strategic objectives are, what the sound bite is, what the theme is, etc. So uh, I look forward to somebody taking on that mantle.
Thank you, Kimo. And Lena Allah, did you have any closing thoughts?
Just mahalo to everyone for your involvement. You know, we're trying our best to listen to voice of community at OHA, and we also have statutory mandates that we have to follow as well. And I think it's an ongoing discussion that we welcome. And I think that there's always, I always appreciate the Aloha Aina warriors who really are pushing the positions that we have a voice, and space really to take from within the system, which is where I'm situated at OHA. So I welcome working with everyone in our community on different strategies, and I think we all have a role we can play together.
Right. Thank you. Mahalo to everyone for being on this webinar, on this forum. This was an educational forum. You can take what information is you find useful and move forward with that. If you do not find it useful, then by all means go forward with whatever information you want to go with. And I want to mahalo to the Sierra Club of Hawaii for bringing us together and laying out the webinar in this format and inviting